6-14230FH. Appearances, please.
Please adult for the people.
Thank you, Your Honor. May it please the court, Patrick Cherry on Mr. Sturdivant II, who is seated to my left.
Thank you. We're here today for a pre-trial conference. This is the initial conference after the case has been bound over and the court issued its scheduling order. I am informed that we have a resolution.
May I approach?
You may. Ms. Dahl, why don't you go ahead and tell me what that agreement is going to say here on this piece of paper?
Your Honor, it is my understanding that the defendant would plead guilty to possession of cocaine, the single charge on that information, and people are recommending 7411 to be disqualified.
Recommending.
Recommending.
Not a kilogram?
No.
I don't know. All right, well, let's find out. Let me see. We got a little while before we get to that.
Yeah.
All right. Thank you. Is that correct?
Yeah. In addition, Your Honor, there is a pending petition for bond violation that would be dismissed as part of the plea resolution.
That is correct.
All right. Has he had any testing since?
Yes, Your Honor. He tested yesterday and tested clean.
All right. I'll accept that as an officer of the court. Thank you. Mr. Sturdivant, is that how you wish to resolve today's file?
Yes.
Please you may remain seated. Please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
You may lower your hand. All right, Mr. Sturdivant, back on March 3rd of this year, were you on probation, parole, or bond anywhere?
No.
All right. Do you have any prior convictions that involve controlled substances of any kind?
I know.
All right, you are currently charged here on a felony information, which is just a fancy way of saying a complaint or a charging document, and it charges you with a single count. That count is possession of the controlled substance, cocaine, in an amount less than 25 grams. That is a felony punishable by up to 4 years and or up to $2,500. I'm told today that you're going to plead to that charge as it reads. Now, there will be a benefit potentially at the time of sentencing. And that benefit would be what's called a killer brew agreement. A killer brew agreement. Well, hold on. Actually, she didn't say killer brew agreement. That's okay.
Yep.
Sorry. By the way, sometimes it doesn't really matter because I do what I want. But there are a couple of different ways to reach agreements with the prosecutor on sentencing. And the best example so far I've come up with is imagine a triangle. You agree, she agrees, and I agree today. That's called a Cobbs agreement. I don't do Cobbs agreements because I think they're silly. The reason why I think they're silly, and I don't mean to say anything negative against judges who do them, is because I may not know anything about you. So why would I agree to a sentence today without knowing more about you? For all I know, you are wanted all over the world by Interpol, and we don't know that, and you're actually a spy from another country. So the reason is I don't commit myself to it until I know more about you. But the other one is called a killer brew agreement. Imagine like a solid line between you and the prosecutor. And that is, if at the time of sentencing, I then don't go along with it, but she's given a killer brew agreement, then you would have the right to withdraw your plea. Now, the agreement that you have right now is kind of like a dotted line or a handshake. That just means that they're going to recommend that I put you on 7411. And if I don't, well, you're stuck with it. Now, anybody will probably tell you who appears in front of me often that as long as you qualify and you continue to do well, then your likelihood of getting it's pretty high. Do you understand that?
Yeah.
Now let's talk about what 7411 is. What do you think it is?
It's some kind of agreement where you don't, it drops off. It's not permanently on your record.
Okay. You're
What I understand.
Yeah, you're about halfway there, or most of the way. So what happens is if I find you guilty today, and then at sentencing, I put you on 7411 status, I'll pick a period of time. It could be anywhere up to 3 years. And if you complete that period successfully, the court will dismiss the charge. Now, if you fail that period, let's say you pop hot and test positive for some substance, then I can, it's within my discretion, take that away and you're stuck with the conviction. You can't go back, you can't withdraw it. Yes, sir.
If I can add to that also, if you miss a test.
Yeah,
Yeah,
it's a
okay.
test. So, Mr. Struman, how old are you?
22.
All right. Now, I used to sit in that, I've sat in both of those seats, but I used to sit in that seat over there. And whenever I had anybody who was under the age of, now, mostly under 21, you're right about there, I would turn to them and say, listen, and I'd tell their parents, the one way he's going to mess it up is marijuana, but that's kind of different nowadays, or he uses again. It almost all the time, not always. Back then, nowadays it's got a little bit different, but I could bet them they would test positive. So the point there is what I'm telling you, and although Ms. Dahl's not speaking, I'm going to say it for her, and I know Mr. Chair would agree. The key is in your hands. Got it?
Yes.
All right, good. So if you enter this plea of guilty today, you're not going to have a trial. Does that make sense, sir?
Yes.
Now, let's first talk about this pretrial agreement one more time, and I forgot to do this part. So I'm holding up this piece of paper that at the top says plea agreement, and at the bottom it appears to have your signature. Is that your, wait. Yeah, that's your signature right there. Is that yours?
It is.
Did you go over all this with Mr. Cherry?
We did.
Did he talk to you about the police report, what it said, what the evidence is?
Yeah.
And did he talk to you about what charges means, your rights are, things like that?
Yes.
And so here's the key question. Are you satisfied with his advice? He's been available for you, been responsive to you and all that?
Yep.
All right. And so far, do you think going along with this pretrial agreement is in your personal best interest?
Yes.
All right, thank you. Now, as I was talking about, if you enter a plea of guilty and I accept that plea, you're not going to have any trial. So now I'm holding up this other piece of paper that at top it says advice of rights. At the bottom, it appears to have your signature. Now, did you read through these rights before signing?
I did. Yes.
Did you understand the words that you read?
I did.
And you understand even more importantly that if you enter a plea of guilty today in a couple minutes, and I accept that plea, you'll be forever waiving these rights as that applies to this particular file. You also, all right, good. You also will be given the right to come back and say, hey, Judge, I was forced into it. Somebody put a gun to my head or whatever. Have there been any other threats, promises, inducements to force or compel you to plead guilty that I haven't heard about today?
No, there are not.
Good. Are you entering this plea of your own free choice?
Yes.
Now, undoubtedly, Mr. Cherry has also talked to you about Michigan sentencing guidelines and things like that, and potential ideas for sentencing. First, I want to tell you that the sentencing guidelines are not mandatory. They are, however, a valuable tool the courts are required to use to help establish a reasonable sentence, but they are again not mandatory. And any recommendations people make are also not incumbent upon me to follow. The sentence will be given by me. Do you understand?
Yes.
Has anyone made any promises to you as to exactly what I would do?
No.
Great, and no one's speaking for me. So do you still wish to enter the plea as we just discussed?
Yes. I do.
As to the single count on this felony information for possession of the controlled substance cocaine, how do you plead?
Guilty.
Before I accept that plea, I need to have you tell me what you did that makes you guilty of that offense. Now, looking back on March 3rd of this year, in Clam Lake Township in Wexford County, what happened? I'm going to guess here, because I see state troopers, were you pulled over?
Yeah. Yeah.
And looks like that was that on a highway?
Yeah, 151.
115?
Yeah, 115. Sorry.
That's okay. Don't worry about it. And at that time, did you have some cocaine on you or in your possession?
Yes, I did.
Where was it found?
In my wallet, actually.
Okay. It was your wallet?
It was.
All right. I've had people try to tell me, well, it wasn't my wallet. I just picked it up, even though my ID was in it.
Yeah,
All right. So did you know the cocaine was there in the wallet?
I did.
How much was it?
3.5 grams.
And so obviously, I think on that size, was it in like a clear baggie or?
Yeah, just a regular.
Yeah, and so you could see in it,
Yeah.
see that there are, and did you know that that's what the substance was?
I did.
Now, this one question seems a bit silly. There's really only one way you could probably answer it. Yeah, but do you believe you had any lawful right to possess that controlled substance?
No, not that I know of.
Not that you know. Okay. All right, Ms. Dahl, are you satisfied with the testimony, statements made by the defendant?
Yes, I am.
Are you aware of any other promises or introducements?
I'm not.
And you believe that so far I've covered Mission Court Rule 6.302?
Yes, Your Honor.
Mr. Chair, do you agree?
I do.
Fantastic, everybody. I love it when people agree with me. So the court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof. Therefore, the defendant is found guilty of count 1. Mr. Studevant, as Mr. Cherry has undoubtedly told you, will be back in about 4, maybe 5 weeks from this coming Monday. We do sentencings in this court every Monday. Where is she going? Okay. Anyways,
To get the packet.
okay.
She's doing all the jobs.
Cool.
It's still going.
That's how you're doing awesome. If I could put you in for a raise, I would, but I can't. All right, so anyways, between now and then, you're gonna have to have a pre-sentence investigation report prepared by an agent from the Michigan Department of Corrections, which is also known as the Probation and Parole Office. So when you leave this courtroom, you're gonna go down to their offices, and they're gonna, this is why I was a little confused, but that's okay. They will normally give you that packet. And then it's okay, don't worry about it, Nicole, you're still employed. You're gonna take that packet down though, they're just gonna say, hey, did you get one of these? Yep, and they're gonna set up an interview with you. Now, you're gonna have to complete the information in that packet. It's a good idea to be as thorough as you can. I'll give you a couple examples. Some people will come and say, well, I was using this because I got addicted to pain pills because I had a broken neck. And then I look on the medical history and there's no evidence of a broken neck. Make sure you're thorough on the information, okay? Now you'll have that interview. You have the right to have Mr. Cherry present during that interview. And the third thing is that Mr. Cherry is going to have to meet with you prior to coming back to court, because you two need to go over that report and to see if there's any corrections or objections that need to be made. People are going to make mistakes, and so they might need to correct something. It's a birth date or a description or a name or a social security number or whatever. All right, so you need to make sure you stay in contact with Mr. Cherry. Now, when you go down to the probation and parole office, do you know where that's at?
I don't.
Okay, do you know where community corrections is?
I do.
If you were to stand there and wave at Misty and Alex, but then do an about face and take 3 steps forward, you're gonna walk right into the Department of Corrections, okay? And you're also gonna make sure you're compliant with your terms and conditions of bond, because how you do on your bond is very critical to me. If you think you need some kind of substance abuse treatment, I really hope that you're seeking it, okay? Cocaine seems to be on the rise locally. We hadn't seen it for years, but sure enough, it's back. So if there's something we can do to help you, I can even order it through community corrections, but I want to make sure that you're getting whatever help you need. All right, Ms. Dahl, anything further?
Yes, Your Honor, the bond violations that are pending, we would like to dismiss those.
Done. Anything else, Mr. Cherry?
That was the only thing I had. Thank you, Your Honor.
Got it. Your bond conditions hereby continue. I'll dismiss that bond violation. All I really would have done is wag my finger and said, don't do that one again, since you don't have any prior criminal history or negative record here in this courtroom. All right, any questions from you today, sir?
No, sir.
All right, good luck. We'll see you here in about a month. Thank you very much for your time.
Thank you, Your Honor.
Take your time. I'll make some notes.
Yeah, TV,